former Deputy Attorney General Alfred Tuah-Yeboah has criticized the Attorney General Dr. Duffuor for dropping the criminal case against ex-Finance Minister Dr. Duffuor and 7 others over the collapse of UniBank. While Dr. Ayine says the decision followed a March 2025 settlement offer covering both civil and criminal aspects, Mr. Tuah-Yeboah argues that the state had a strong case and should have pursued full prosecution to cover all funds, not just 60% of the proposed settlement.
When we took it to court, we had 3 or 4 objectives. 1, to prosecute, and if successful, get them convicted, and then also get the money recovered after their conviction. And in addition thereto, for them to also be punished in accordance with law. And so in terms of recovery, we know who that one out, but we're so clear in our mind that we had a very strong case, and that if nothing at all, at minimum, even if we're going to settle the matter, we should get 100% recovery.
But the AG makes the point that during the period that you were on this case, you made no inroads in terms of getting conviction, in terms of the recovery. For all those years that the case stood in court, no progress, no significant progress was made in terms of getting to the finality of, and what he's done rather has saved the nation money that in terms of legal journey would have amounted to nothing.
Respectfully, I disagree with the learned AG. This case started in 2020. We called the receiver. In fact, he was our star witness. The receiver appointed by the Bank of Ghana. He went through the books, came out with the figures that we used in filing the charge sheet. He came to testify. He was cross-examined. We also called our second witness, PW2. And so if there's this saying that we didn't do anything apart from filing it, that cannot be true. Then if you also look at the charges that we leveled against the accused person, you realize apart from falsification, apart from falsification of account as one of the offenses that we charged the accused person. The point has been made that no recovery was made, but the AG knows that before he took over, 300 million Ghana, the amount that we charged the Bank of Ghana, current Bank of Ghana with, has recovered. But this notwithstanding, we're pressing the charges because we had the view that if someone did something untoward regarding finances and we're able to recover even 100%, the next step must be taken to also, in a way, punish the person, either getting the person imprisoned or let the person pay interest or restitution in addition to the original amount. So that's the very reason why this case was in court. We did a lot. It went to the Court of Appeal. It came back. They raised various objections. And so when I heard the AG say that he has examined the file, realized that the charges are weak and the possibility of current conviction was very minimal, I beg to differ.
Well, according to Mr. Tuah-Yeboah, the Attorney General's decision to set is setting a troubling precedent that could weaken, other cases in future.
It's where we took serious steps to file the charges, line up our witnesses to prosecute it. With this new trend, what is being said, or what we are trying to say is that the other case in court, for instance, now we have the UT case in court. The same market protecting have the same set of facts. We have other, I'm not enough, but I know we have about 6 or different cases. The agents are telling us that all those cases will not be successful in court. And this is now going to arm the accused person, no case to say, we are not going to pay you even once, because after you said that the cases that we file in court are not strong cases, and you will need to recover even once to be. So I think the approach is something that I have a problem with. The AG simply could have entered NP, which I will not doubt he has that power to do. And then perhaps spare this explanation. But with these explanations, we are also fortified to also come out. And it's not helping the cause, because the AG has cited an example that because 10 million was offered by Page Capital Inaku, and he rejected, and now the guy has been acquitted and decided that the state has lost everything. I beg to differ on that score also. That's why we have the Supreme Court. If the High Court has made a ruling that the person has a case to answer, and the Court of Appeal has said the person has no case to answer, any prosecutor may want to go up because the trial court, which heard the evidence, has come to a conclusion that you think that you ought to move forward. But if they are saying that they are going to appeal to the Supreme Court, what happens? It means that, as he said, we are going to lose everything. But how much was involved in the Beige Capital case? For 1.2 billion Ghana cedis. And which prosecutor will accept 10 million in settlement of an amount of 1.2 billion Ghana cedis? So, everything.
Right.
This 60-40 that the AG said they've come up to is a dangerous precedent, even though I concede that if we recover some amount of money, it's good for the state. However, we need to be very careful, very cautiously. I know as a fact that there are over 400 cases involving the banking sector cleanup. With this precedent, and with what the AG has said today, I doubt if you can even get one CD in the other case. Because the AG has said that for the breach of trust does not hold in such cases, he seems to be saying the other offenses will also not hold. Check the other cases and realize that these are the offenses or the charges that are leveled against the other accused persons. That's what I'm saying. It's a dangerous place and we need to watch out.
Meanwhile, lawyer for embattled Ashanti Regional NPP Chairman Wontumi says they're exploring all legal options, including plea bargaining, only after specific charges are made. Yoko has completed investigations into Wontumi and former Buffer Stock CEO Abdul Wahab Hanan, with findings expected soon. In their Akonta mining case, charges have been prepared and returned to the police for arraignment. Lawyer Andy Apiakobi says they will decide on a course of action once the charges are fully known.
Well, let's wait for the charges to come. We'll make appearance to court and we'll see the options.
And just to be clear on his offer to plea bargain, you're saying that once you see the charges, is something that you would or you may consider?
Well, it is part of the considerations that we'll be able to resort to. But until we are served with the charges, we have not been served with any charges whatsoever. So when they are so set, then we will consider all possibilities.
Lawyer Andy Apiakobi insists his client deserves a fair trial and is ready to face the AG in court.
He has a duty also to ensure a fair trial and also give the accused adequate time, opportunity, and resources to be able to defend themselves. So I'm sure that we'll be accorded the necessary courtesies as we make appearance in court. So we are ready.